There's been another arrest, not of a gangster, not of a corrupt official, but of a 22-year-old law student, Sharmistha Panoli.
And law student Sharmistha Panoli has been sent to 14 days judicial custody after her arrest for a controversial video that allegedly hurt religious sentiments. The now deleted video, posted on May 14, criticized Bollywood celebrities for their alleged silence on Operation Sindoor and included communally charged remarks.
But this isn't just another internet controversy. It's about where we as a nation draw the line between freedom of speech and religious hate speech. So let's break it down legally and rationally. Sharmistha Panoli, a student of Symbiosis Law School, was arrested by the Kolkata police from Gurugram after she allegedly posted a video on Instagram that was accused of being derogatory and offensive towards Islam. The complaint was filed by Wajahat Khan, who claimed the video could incite communal hatred. Within days, Sharmistha was taken across states and sent to 14 days of judicial custody in Kolkata. The internet was split. Some saw this as justice, a necessary step to prevent communal violence. Others saw it as a crackdown, a dangerous precedent for punishing dissent or unpopular speech. But then there's a twist. The complainant himself, Wajahat Khan, was booked by the Kolkata police, raising even more eyebrows. Turns out, after digging up his social media, there were posts people thought were derogatory towards the Hindu community. Ironically, this really raises the question on how legit the original complaint and the subsequent arrest were. Let's get to the heart of it. Does India really guarantee absolute free speech? The answer is no, and for a good reason. We all love quoting Article 19 Clause 1 Clause A of the Indian Constitution. It gives us the freedom of speech and expression. But right below it, Article 19 Clause 2 sneaks in with a caveat. Reasonable restrictions can be imposed in the name of sovereignty, public order, morality, defamation, or incitement to an offense. So what laws might be used to impose restrictions on free speech? Section 153A of the IPC criminalizes promoting enmity between groups on religious grounds, which is Section 196 under the new criminal law BNS. Section 295A of the IPC penalizes deliberate acts intended to insult religious beliefs, which is Section 299 of BNS. Sections 499 to 500 of the IPC deal with criminal defamation, which is Section 366 in BNS, and the IT rules of 2021, which empower platforms to act against harmful content online. The aim is to curb real harm. The danger is misuse to silence dissent, unpopular opinions, or even political rivals. And that brings us to some landmark cases. First, Romesh Thappar is the state of Maharashtra of 1950. This was one of the first free speech battles in independent India. Romesh Thappar, a journalist, had his publication banned by the Madras government for being critical. Supreme Court struck it down, stating the freedom of circulation lies solely with the establishment and Madras could not interfere. It was a win for liberty. Second, Shreya Singhal versus Union of India case of 2015. Remember the infamous Section 66A of the IT Act? It allowed arrest of offensive social media posts. Two girls were arrested for a harmless Facebook post after Bal Thackeray's death. One posted, another liked. The case reached the Supreme Court and Section 66A was struck down. Why? It was too vague, too broad and violated right to free speech. Third, Arnesh Kumar versus State of Bihar. Not just a free speech case, but hugely relevant here. The Supreme Court said police shouldn't arrest casually for offences less than 7 years of punishment without proper inquiry. It was meant to prevent arbitrary arrests, exactly what critics say happened in Sharmistha's case. So where do we draw the line? Yes, India cannot afford communal hatred. We've seen its dangers, but we also cannot become a nation where every unpopular opinion is branded as a crime. Because then who decides what's offensive? A government? Well, that might just silence criticism. An independent body? In India, power and money often have a way of influencing this. That's the real problem. We need regulation, but we don't trust the regulator. I've always believed freedom of speech must come with restrictions, especially when it comes to misinformation. In fact, I've done a full video on misinformation laws in India. Do check that out after this. But deciding who gets to defend harm is where things get messy. The arrest of Sharmistha Panoli is not just about one person, it's a litmus test of how India handles online speech in a deeply polarized digital era. Should she have been arrested or was it overreach? Honestly, that depends on whether you're reading the law or reading the politics. What do you think? Was her arrest justified, or are we dangerously close to turning our democracy into a silencing machine? Let me know your thoughts in the comments. I read each one. And if you like this kind of legal deep dives, don't forget to subscribe to our channel. And until next time, stay informed and stay empowered. Thank you.